Emily, and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in New York and Connecticut. My question today for Attorney Murphy is, what is the difference between mediation, litigation, and arbitration?
Thank you, Emily. In a family law case, there are differences and similarities between the three things you mentioned. Mediation is a process where the parties go about hiring the services of a neutral. That neutral can sometimes, but not always, be a lawyer. That neutral person is hired not to act as a judge, not to make any findings or to weigh the evidence that's presented, but rather that person is there to help facilitate a resolution of the disputes, to help people craft an agreement after collecting some information, whether it's financial information, custody information, parenting issues, and really the job of mediators to hear both sides of the circumstances, whether together or separately. Sometimes it'll be everyone in one room, sometimes there will be breakout rooms, and usually this occurs over several sessions. And the mediator's job is to help the parties reach and ultimately craft an agreement which would capture any particular agreement between the parties. A mediator can suggest certain avenues that they might want to explore in terms of parenting plans or division of assets or alimony or something like that. But ultimately, the decision and the agreement is up to the parties, whether with or without advice of their own independent counsel. The mediator's job is not to give legal advice, but rather to help them sort of come to the middle, so to say, and to do the best to resolve disputes in a less adversarial way. Litigation, on the other hand, is using the courtroom to resolve disputes. So litigation or trial work is presenting a story, as you see on TV and as people know about, presenting the story before a neutral fact finder. In this case, it would be a judge. And that person, the judge, is ultimately tasked with deciding a fair and equitable resolution to the conflict, whatever that may be, and coming up with a fair and equitable solution to a particular problem. This involves exchanges of information as well between the parties before going to trial, obviously, before going to the court. But the discovery process is a little bit different. While there are documents that may go back and forth, for trial work and litigation, the attorneys involved are going to want depositions. They potentially could want expert witnesses, and they're going to be focused more on the presentation and preparation of exhibits and documents and demonstrative evidence that's designed in a particular way to help sway the opinion of the judge who's going to be ultimately deciding the case. Arbitration, the third thing you mentioned, is another option that's available, and essentially that is hiring a private judge, a private individual to serve as a judge, as sort of a quasi-judge out of the courthouse to make a decision that becomes binding. And in a family law case, that's increased in popularity, although in Connecticut, this can be done for everything but custody. An arbitrator cannot decide custody on a binding basis, but all the financial decisions as far as division of assets and support and those kinds of things can be decided by an arbitrator. So those are the three different methods.
How do I know which option would be best for my case?
So that's a very particular answer. There are a couple things that weigh into it. Mediation and arbitration are both much less expensive than litigation, especially if litigation goes the long haul and goes all the way to a trial. But people should realize that mediation and arbitration might not always be necessary. And sometimes the most expensive route could, in fact, be going towards mediation, attempting a mediation with neutral, failing, and then going towards litigation, where you've incurred the cost of mediation and litigation as well. Parties should also realize that the vast majority of cases are on a litigation track, but where the parties decided not to hire a neutral, but yet with the help of competent, reasonable attorneys, the parties are able to craft an agreement out of court in advance of the trial, sometimes in advance of depositions, sometimes in advance of some discovery, in a way that's fair and equitable and ultimately saves them time and money.
If the parties reach an agreement, do they still have to go to court?
That's a great question, something I'm asked often. In a mediation, Actually, in all three mechanisms that I talked about, to some degree, the parties do have to go to court. In a mediation, usually what you're doing is, like I said, you're drafting an agreement which becomes a separation agreement. You're going to be ultimately asking the court to adopt that agreement and make it part of a court judgment. So yes, in that case, you do file a summons and complaint, and you do ultimately show up in court for what's called an uncontested hearing, where the parties are basically standing by their agreement, indicating that this is what they want, and asking for the court to decide that it's fair and equitable. A similar kind of thing happens with arbitrations, although usually we go to court first to have the arbitrator approved and the process approved in advance. And then again, we submit the arbitrator's findings to a superior court judge for ruling on those. And litigation is obviously the circumstance where you're going to be in court most often. And the judge is ultimately tasked, whether it's in litigation or mediation or arbitration, at that final uncontested hearing to decide whether the agreement before him or her is fair and equitable, if it's in the best interest of the children, and if the parties realize that they could have gone to trial, the result may have been better, may have been worse, could have been different, but this is ultimately what they want, what they're asking the court to approve.